All right, everybody. Justice is Process back here. We are back for day 9 of the Jennifer Crumbley trial. Jury is still deliberating. They've been at it now for about 2 hours. So I figured we'd come in here and start the watch like we did yesterday. So going to go over a few things, though, while we're waiting. There's a few clips I decided to pull out that I thought would hone in on some of the points that I made yesterday. Didn't get a chance to put together a full video. I was going to do that, but thought, you know what, we'll do this as part of the jury deliberation while we're waiting. So we can talk about that. But as of right now, looking in, jury is actively deliberating. There's been no word from them. They started at about 9 o'clock. So far, no word. There was 2 questions yesterday. The final question, which was asking if they could infer anything from the lack of a witness's testimony, I think was telling of the direction this jury is heading, and it's not in a good direction for the prosecution, it seems. My thought is there's probably 1 or 2 in that jury room that are struggling with the idea of going full not guilty and letting her walk out. Just they have that inkling, they have that feeling that she's responsible for something and they don't want to let it go. But the bottom line is the evidence just doesn't support that. And I think, resoundingly, we see that around, that that's pretty much the feel. Anybody that looks at the evidence of this case says, hey, the evidence doesn't support the charges, but we feel like she wasn't a good enough parent. She didn't pay enough attention to him. And some people want some sort of justice for that. So here we are as they're debating this. The problem is that obviously what this case means for parents around the country is tremendous, because you're talking about the potential here that prosecutors could take a manslaughter law, if this goes unchallenged and unchecked and survives appeal, that prosecutors in other states and other jurisdictions and other counties could apply this to a multitude of things. They could apply this to kid goes to school and gets in a fight, and they say, well, that child was troubled. And the police take his phone and they get search warrants for the parent's phone, and they say, hey, this kid was texting that he was going to get in a fight. This parent didn't do anything about it. And then they start analyzing and cherry picking pieces of messages and interactions from 6 months ago, and says this parent didn't do their part in recognizing that this child was on the road to an assault of a child. So now we're going to charge the parent with, a failure to act and go after them. So it's a disturbing thought process with the way they're applying this, because it's a dangerous road. Because what we're doing is, as I mentioned yesterday, we're charging Ethan Crumbley as an adult. We're putting adult responsibilities on him, which we seem to be okay with, because we just want that mercenary, bloodthirsty punishment, while then reverting back and saying, well, wait a minute, he's a child and we want to punish these parents over here because although he's an adult who was adult enough to do a crime to a level that rose above all other children and gets him life without parole, at the same time, this same extraordinary individual who was well beyond his years of development and ability, that doesn't apply as a defense to the idea that these parents got bamboozled. No. Should have been so obvious. But yet it wasn't obvious over here. So we're gonna say no, it's just this extraordinary case. And this is a case of where we're reacting and we're punishing. We're doing exactly the opposite of what our criminal justice system calls for. And that is, we're trying to punish after the fact. We're trying to apply laws after the fact instead of applying the laws that we already had on the books. And if we can't prove a case, If the laws don't apply, the prosecutor shouldn't have brought the case. But instead, they brought the case, and now they're trying to stretch the case to fit a theory of conviction, and that's a concern. But double checking here, make sure nothing's going on with this. So the first clip I want to show everybody on this is the clip that I think starts it all. This is why, when you ask, why was Jennifer Crumbley charged? Why was James Crumbley charged? And you're going to see why. And the charges themselves, why they're charged, how they're charged, is upsetting. When you see why they were charged, and when you watch this video, which was played in the trial, you're going to see that the police, when they first come in this room, they're getting James Crumbley water. They're friendly. And then they bring up one thing. They say, we should get a lawyer. But the individual that does that, I want you to watch this, because I don't want you to think, oh, this is just justice as a process. Steve's just going off on conspiracy land. No, I'm not. You just got to watch the details. The devil is in the details. And in this case, watch what happens here. And then watch what happens a little bit later as well. So let's jump into this video here. Give me a moment. I'm going to pull it up. All right, so this is the interrogation video, and we're going to watch at least the beginning of this. We're not going to necessarily watch the whole thing, but it's relevant to watch the beginning of this to understand what I'm talking about. So let's play this.
Correct.
Now, I want you to watch the interactions, how the interview is at the beginning when these parents and police walk in. They're all on the same team. And watch how it changes. And this is the moment the Crumleys become the target.
This is you in the blue shirt.
It is.
And the individual to your left in the video is who?
My partner, Rob Miller.
Okay. Individual with the hat.
James Crumbley.
And the female in the video.
Jennifer Crumbley.
Okay. And again, this is 1:58 and 59 seconds, November 30th, 2021.
Yes, sir.
Now that's significant. Now that's significant because I want you to watch. This is at 1:58. The next video we watch is less than an hour. Okay, less than an hour after you see them leave, and you're going to see how this whole thing goes down. I'll fast forward to the end so you can see that part. But less than an hour after they leave this interview with the police, watch what happens and tell me. You cannot tell me that it's not related to how this thing ends. Let's watch.
Obviously, we don't know all what happened yet because everything's still ongoing. It's our understanding he wasn't involved in a school shooting. He was the one who did everything. He said he acted alone. That's basically the only thing we've asked him so far because there's worried about other students or other people that have done it. I guess want to get some questions from you, or ask you some questions first before we even start talking to him. Is there, I hate to stop you. Is it possible for me to have a word? My mouth is full. Yes, I'll get one. Super dry, breaking out. He said that first, was there any fatalities in your home? That we do not know. There are several people who've been shot though. This is my partner get back. Okay, look at him a little bit. But we really need to talk to him. So if we can do that. Everybody morning.
All right, so I want you to understand what just happened there. If you're listening to the conversation, it's hard to hear because this was being played in court, right? But he says, we really need to talk to him. We really, the first guy's explaining that there's they've got potential reports that there's people that are that you think that there's reports that that there could be others involved, and they need to eliminate that. And it's they're making the case, they're laying the case out for why they need to speak to Ethan Crumbley. And to understand this, the significance of this is because he's a minor, he is being treated as a juvenile at this point, even though he'll later be treated as an adult. That hasn't happened yet. So as a result, his parents are a gatekeeper to them being able to speak with him, to him being able to waive rights like his right to Fourth Amendment right to have his phone searched, the right to come in and search the house and look in his room. So these are all things, obviously, that most parents, when their child is in the situation Ethan Crumbley's in, they'd be in there with the police. And in most cases, these children speak to the police. Some states, like Florida, they actually allow the police to speak with a juvenile without having to have any intervention from the police. They're unique in that sense. The parents don't have to waive that right. But in the state of Michigan, they have to waive the right. So they are acting as a gatekeeper. So the reason why the police are in here buttering them up, getting them water, they brought them in. They're like, oh man, this is great. They've come in. We really needed you here. You can see the gentleman right here. This gentleman, he's writing down information. He's actually writing that. What that is on the desk, I believe, is a waiver form. That it's their intention while having them here. They know they've got Ethan in the other room, and they're going to say, okay, we'll have you sign this waiver form. And then what normally would have happened is if they would have been cooperating, they would have been allowed to go in with Ethan Crumbley, which the police would have been okay with because they would have wanted to observe the conversation between them and Ethan Crumbley. They would have had them sign the waiver form. It would have been clear they were cooperating, and their expectation was the parents were going to be like, listen, we got to figure this out. We can't believe this. This is horrible. And they're going to be bowing down to the police and saying, investigate my son. And at the same time, what they're ultimately doing is they're ensuring their son's conviction here. They're ensuring that their son is, they're going to help with the case to just, put their son at the mercy of the court. That's what these officers are expecting. But Jennifer Crumbley does something unexpected because James is ready to talk to the police. Jennifer does something unexpected. And it is not a coincidence that Jennifer Crumbley ends up in handcuffs less than 40 minutes later. And I don't care if the police claim that there was no communication between the forces that came to her house and that were here sitting in this interrogation room. I don't believe it. They're all knowing what's going on at this point. And I believe 110% you're going to hear in a little bit Jennifer Crumbley literally freaking out, saying, why am I in handcuffs? And James Crumbley saying, why am I in handcuffs? And there's a reason why, because they wanted to humble Jennifer Crumbley. Because in this interview, you see she's on her phone. She's got kind of a little bit of an attitude, but I don't really think she has an attitude. I think that might just be her personality and how she comes across. But essentially, she pisses off the police. But the real attitude that they take from this is, you asserted in this situation where we ended up having 4 people die. I think there was 14 or 15 people being transported to the hospital at this moment. And you're coming in here saying, my son needs a lawyer. And we don't know what the situation is, and we can't talk to him, and you're going to hamstring him and you're going to keep him silent. Oh, no. So what do? That's why they sent a SWAT team over to their house, guns drawn, semi-automatic weapons, in her face, in his face. She's in cuffs. She's brought to the car, put in the car, and made to sit in the car. And it is meant to drive home the fact that, listen, you want to be against us in this instance? We're taking the gloves off. We're coming in. And now, not only are we going to investigate your son, but now we're going to investigate you, because we have to assume, since you're invoking a lawyer, there must be something you're hiding. Maybe you were in on this with your son. We don't know. Maybe you planned it with your son. Or better yet, the theory they ultimately come to is you didn't do enough to prevent this. So now you're getting charged as, under the theory of involuntary manslaughter, gross negligence. You didn't do enough to help your son, and we're going to cherry pick little pieces to make this case, because you know what? We want to send a message across the country that if your kid does a school shooting and you don't cooperate and you don't bend over backwards to help the authorities lock your child up and you assert your rights. And to me, this is something I really wish would have been made a bigger issue in this trial, because this is the core issue, in my opinion, of why this ended up to where it ended up. You may not like that, but I'm telling you right now, watch what I say and watch what happens, because I believe that what happens here and what happens in about 40 minutes based on the timestamps are inexorably linked. There's just no other way to say it. So let's watch.
Ethan Crumbley, and James, what is your date of birth? So, we're coming in this very early, but when I say there was an issue just recently, was that? This morning. What went down this morning? Well, he was writing, yes, show them the picture. He was doodling on a test, or a practice test.
Do you think we should probably have a lawyer?
That's up to you.
I think we probably should have a lawyer.
I think we can speak
I know.
to the cops, and
Just
we'll
follow the lawyer.
these. And here's our perspective right now. This thing is still very, very fresh.
Right.
Right, people are still on their way to the hospital and such. We need to know what his state of mind is. Is there explosive devices anywhere? Is there other guns anywhere? Did he hide guns, ammunition, explosive devices? Are there any other victims? We need to know these things quite rapidly.
I was in town. I saw all you guys go to. Okay.
All right, so there you have it. You saw the reaction of this police officer, right? It's pretty much like, are you kidding me? We have an active situation, and unfortunately for this police officer, is this is when the Bill of Rights gets in the way. I understand, but Ethan Crumbley has no obligation to speak to the police about this. He has no obligation to incriminate himself about this, and his parents have every right to invoke this right, but they don't like it. You could see he took his glasses off, and it's like, are you kidding me right now? We need you to cooperate. We need you to sign over his rights. We need you to let us interrogate him, and we need you to let us do what we need to do. And you can see James Crumbley is like, we want to talk to the police. There's a reason why he ends up in no handcuffs. Now, if both of them were in handcuffs in the video you're going to see here in a few minutes, I would say, okay, yeah, that was just protocol. But she ends up in the handcuffs. She's sitting in there, blocking their way, blocking their job in their eyes, in the middle of what they said is just in their eyes an unheard of crisis. Their son has shot up a school. They don't know if he's working with anyone else in their eyes. But the reality is that here's the deal. If they were really worried about it, they could go ask him those questions, right? And get the information. It just wouldn't be admissible in court. See, the cops here are lying too, because they say, "Oh, wait a minute, we need rights. We need permission to talk to him. We need to find this information out because it's all about saving people." No, it wasn't. It was about him incriminating himself, securing the case, and locking him in. And they wanted to be able to use it against him in court. But if there was exigent circumstances like he's talking about, right? If there was truly exigent circumstances, they could question him and they could admit it past exigent circumstances, and say, hey, well, maybe we can have the state attorney argue this. Are you kidding me? Do you think that they wouldn't have already asked him and said, is there explosives? What's going on? None of that is true. They're lying to the Crumbleys, because the reality is if the judge, when they pull him into the car and they start talking to him and say, hey, son, you did this, Yeah, I did this, officer. Is there any other guns? No, there's not. Is there anything else? You don't think they haven't already had that conversation? It's just not admissible. That's the only thing they're looking to do is try to get stuff admitted. So this idea, which again, this is played to the jury. This was played to the jury to make them look bad, to make them look like, hey, they're not cooperating. Because the message here is, in this case is all about an overreach by the state. And this is about the state saying that they're, again, you heard Julie Grant probably about 6 months ago on Court TV talk about the father that killed his 3 kids. And she said, we think there should be special circumstances that he doesn't get the presumption of innocence. And in the state of Michigan, they say, we think there should be special crimes that you don't get the right to remain silent, that you don't get to assert the rights for your kids, that you as parents are going to have your actions reviewed differently. There's a different standard because of the action. No, that's not how it works. And if that's going to happen, it's got to pass through the legislation. It's got to go through constitutional requirements. It's got to go through all of them. Yep, Chad Doberman, that is correct, Jan. Yep. So that is the concern here, that we don't carve out special stuff. That's not how our justice system works. We pass a law. We make sure it's a constitutional law. It goes through the process at the state house, becomes law, can be challenged and appealed, and we make sure it's constitutional. In other words, it applies to all of the constitutional provisions. We make sure that it meets all the due process requirements. Make sure that it's not vague, that it's easy to interpret, that if you put 10 or 100 people in the room, everybody's going to understand what the requirements are and what you got to meet. But we do not carve out special circumstances to where we say, hey, our Constitution gets suspended, our Bill of Rights gets suspended. No. Because see, what happens is, once we make that carve out, like they've done in this case, where they said, well, manslaughter wouldn't normally apply, but we're going to elongate it in this instance, and we're going to stretch the causation requirement, and we're going to say, well, normally we understand that, the fact that Ethan Crumbley was charged as an adult and was making his own decisions, and it's this special case where they stretch him to an adult, give him life without prison or life without parole. Normally we would have said, yeah, you're right, he broke the causal link because it was his own gross negligence in how he acted. So as a result, we're not going to blame the parents. And plus, on top of that, it's a stretch. How would the parents, if this kid is so diabolical, is it a stretch to think he fooled his parents just like he was obviously fooling the school staff, just like he fooled a trained counselor? Of course not. But no, state of Michigan says, no. We're going to cherry pick a few messages. We're going to look at this and we're going to say, guilty. Because 6 months ago, he said he heard what he thought. He was claiming, and again, you have to look at the context of what was going on. He was in the middle of discipline process, having his phone and stuff taken away. All right. So we're going to listen a little bit more on this, and then I'm going to play the next here. But we're also look at how things end as well, because that's important. Hold on one moment.
When I see 5, I start concerned. I headed to the high school, obviously couldn't get to the high school, turned into the Meyer parking lot, and I saw these kids standing outside. I'm trying to call my son, make sure he's okay, and
He texted me that he loved me.
He texted you that?
and somebody said that there was an active shooter.
35 minutes
I
before he called me,
immediately,
I was
freaked out
I was
because
down
of
to the school.
the
He
situation.
was drawing that on the paper and the counselor called me down.
So really, what did the text say?
No, but it was texted to me
Oh.
from the counselor.
From the counselor?
I text Ethan at 12:21, you okay? He said, yeah, just got back from lunch. I said, you know, you can talk to us, we won't judge. He goes, I know, thank you, I'm sorry for that, I love you. I said, I love you too. And then, you okay? And hear back. And then he told me about what's going on, and I freaked out and then drove here from work. And
That's where we're at.
that's where we're at.
What time did you text him?
That was at 12:21, and he was just getting back from lunch.
So you guys had a meeting with the counselor this morning over
Yeah.
the rule?
Yeah.
Can I say real quick against this? What, was it the first hour, second one, what time was it?
I got to school at 10:30, I don't know what I
So
remember.
it would have been earlier, first or second, I don't know.
And what did he say?
I mean, he just said he was sorry, he just said, you know, like,
Does he have an issue, like being hit down?
No.
Or?
No.
not that we know of, his best friend, his parents just sent him somewhere to Wisconsin for an OCD rehabilitation. That was his only friend that he had, they hung out all the time, at school. Our dog, our Great Pyrenees, just passed away a couple months ago. My mom died back in April, so that's.
She's got all the structures going on.
They didn't.
They say, I mean, did you guys go over this with him, like, what exactly does, like, totals? Anybody ask him what the total was?
No, the counselor,
The counselor just said, you know, there's no,
I didn't even, honestly, I didn't even like think about that, 'cause
I mean, it's Ethan, Ethan's like, he's a perfect kid, he doesn't do anything, he doesn't get in trouble at school, he doesn't,
is that how,
That's your guy? What kind of?
it's a six-lawyer, man.
What was it?
It was hidden in our arm, in the case, and bullets were hidden in a completely different spot, underneath some jeans. I raced home, and I'm the guy missing.
After you saw all the cops?
After I saw the cops, after I found out it was an active shooter, after what went on this morning, I immediately raced home and found the gun in his hands when I called you guys. I called you guys right away and let you know.
Where, how far away is your guys' house from the high school?
like, right
We live
across
on
the
E Street.
I'm not familiar with that.
Oh, he walks, he's going from school,
School.
it's really right in the village.
So what we'd like to do, is talk to your son. And obviously you mentioned earlier, our lawyer, he is totally entitled to money. That's gonna be all up to you guys, but it's his age.
We would like.
I'm messaging Andy right now.
Okay. Can Andy handle,
Andy can get me something.
we would like a lawyer present
Before you any question.
from here on out. Okay. And no disrespect to you guys, it's okay. It's just, we don't, I don't want to have on this one. I only see this stuff on TV.
At school?
All I know is I talked to the counselor about that, he texted me, and we went down there, met with him.
That's all that was about.
That's all it was about. And he didn't seem worried about it, and he said he could more welcome to stay at school, or he could go home, and I really wish we
Would have taken.
could go home.
Is this, or is that?
She didn't help here.
So you could see there, right? Once again, they make it very clear. You can hear the police. They said, no disrespect to you guys. We really need to talk to them. We really want to talk to them. And you can just see the whole tenor of the conversation at this point has changed. And the Crumbleys dig in. Miss Crumbley says, absolutely, we're not having a lawyer, or we're not going to speak anymore without a lawyer. Ethan's not speaking to anyone without a lawyer. You can see the police are frustrated with that because, again, for them, they want to be able to speak to Ethan Crumbley and have him give a full-out confession and just wrap this thing up in a tidy little bow. But they've said, no, we're not going to. Now, inadvertently as well, they're talking about this sheet that they saw at the school, and they're also speaking to the police in a sense that they're saying, we have something to hide. At least that's how the police are going to view this. But most importantly, these police officers are thinking to themselves, listen, you're really going to assert your rights in this instance, not let us speak to Ethan Crumbley, not let us speak to this kid who just shot up a school. Well, guess what happens? Again, it's not James Crumbley, although he, again, as you see there, he follows the lead of his wife, and he basically speaks for them and says, let's be clear, we want a lawyer from here on out. And then she makes the statement, we really wish we would. Listen, everything about this interview speaks. These do not look like parents who are sitting here going, oh my God, I think I wanted my kid to shoot up a school, which is what you have to assume in order to get to a guilty verdict in this case. You have to actually think that they were at the school thinking to themselves, man, I think he could do this, but I'm just going to ignore it. I'm going to ignore it. I'm not going to do anything. You heard what she said. In hindsight, she listened to the school counselor. The school counselor's like, let him stay, let him not. The whole tenor of the conversation at the school is not anywhere near where they're thinking their kid's going to shoot up the school. You heard truthful statements. He had no disciplinary record. He had no issues. Obviously had some, behavioral issues in relationship to getting his phone and video games taken away, but a lot of kids do that. Some might say, well, he said he heard. Well, again, like she said, there's a they thought they might have a poltergeist in the house because it was a fixer-upper, and that was an ongoing joke. And, again, it's the idea that, do you believe at that moment with the 6 or 7 the text messages that were sent out, I think it was 2 or 3 text messages sent out at the beginning of April, and then nothing. There was nothing else in the phones between April and November. Everything else that was said outside of the earshot of the parents. It was written in a journal that the parents never, ever saw. And Ethan Crumbley obviously felt that he was ignored by his parents, that he wasn't given the attention by his parents. But again, they have to have known this. We know Ethan Crumbley and his dad spent time together, going to the gun range, hanging out. You can tell they had a close relationship because his dad's sobbing and crying right there. Well, you're going to see that in a moment. So it's pretty clear that, to me, this video is an exculpatory video in terms of looking in and viewing in of just the mindset, because that's what's important here. It's the mindset of these parents. But what's most important here, we're going to skip ahead now at this point to the end. We'll go in and see the final interaction when they assert their rights for the final time. I want you to look at the timestamp. Now, I want you to understand it says 15:07 here on this, but it's an hour ahead. This wasn't adjusted for the time change. So this was an hour ahead. So it's really 2:07, and that's going to be important because when we go to the next video, you're going to want to look at the timing of what happens in the amount of time that passes before these police officers, who you can tell are getting very upset. They're very frustrated here. They're not happy that the Crumbleys have asserted their rights. And watch what happens, and watch who it happens to, because the whole person, the individual these police officers view as the person that's impeding progress here is Jennifer Crumbley. The dad started out willing to talk. In fact, he was saying a couple times, like, can't we just talk? And then she was saying, no, Andy's going to get us. That's her boss. Andy's going to help us get an attorney. We can get one really quick, but we want to talk to an attorney before we go forward, and we want an attorney present at all interactions, which to the police mean, okay, we're cooked here. It's over, because that's not how they want to operate in this instance.
For the time being, he's been arrested once. He's going to either jail or service military for a short time. So we're going to talk to him. So 5'11". How much do you weigh? Eye color? Hair color? Okay, so we were gonna ask you a bunch of questions about why you did this and get your whole side of the story. Your parents want to retain insurance, so we'll not be asking you any questions about the incident that you were involved in. Your parents popped in here to get some basic information. You will have a contact with them eventually. We'll be taking you to either Oakland County Jail or Children's Village forthwith, get you lodged after we take all your clothes and everything to jail. Any questions for me? You have to ask, it's up to you. If you want to ask me something, go ahead. I don't think we need to ask any questions right now. Okay, pop up. I'll back up. Please say your story.
Why?
I love you. I love you. I love you. I love you. You guys. I love you. I love you. I love you. I love you. You guys.
Didn't even like care. What the fuck?
You have our information. Do you have any questions for us? So typically what happens is, now we haven't done you.
Somebody contact us and let us know where it's going to be.
Corporal. Yeah.
When?
A day or two. Could be today, could be tomorrow. And so wait a minute, right? So right now, I really don't care about,
We understand, right?
so somebody will be in contact
Okay.
because of his age. Yeah.
Okay.
All right, so you saw the end there. Unfortunately, the timestamps got moved because of the way the court was moving. But the idea here is it's probably about 2:25, I think, because when they cut away in the court, you could see the timestamp. I think it's about 2:25. So they leave. And then we're going to move on to what happens next. And I want you to pay attention to the time of day this is, that this occurs, who it happens to. Remember, they've just left. The police have made multiple attempts. They brought the parents in. They tried to get them to waive rights then. They reiterated, are you still sure about this? You still sure you don't want to talk to us? And they said, no, we want a lawyer. So at this point now, the parents, the police, you could tell by the tenor of that conversation, these guys were like, you know what, be a day or two, we don't know. It's basically, it's not our responsibility anymore. He's getting locked up. You guys chose not to cooperate. We're not offering you anything more than what we have to. He's a juvenile. You're getting informed. Go from there. So next video here. Give me a moment.
All right, you may be seated. Lieutenant Willis, you're a Stoner, all right?
Yes, Your Honor.
Go ahead, Officer.
Thank you. Sir, you mentioned earlier that you directed officers to the Crumbley family home at 112 East in Oxford?
Correct.
Okay. And approximately how far in distance is that home to the school?
A mile.
Okay.
Yeah.
And as officer in charge and as a sheriff's office employee, you're aware that vehicles have in-car recording capability?
Yes.
Okay. So I'm going to show you what's been, I believe, stipulated to is Exhibit 341. This is an in-car video of Deputy Zajak's marked patrol car. That's 341.
I'm sorry, I'm just. Was that admitted to Joe Bryan or not?
No, just 342 was.
And, I'm sorry, we have no objection to 341.
Right, 341 is admitted.
And, sir, so we're clear, the deputies arrived at 112 East at 2:48 p.m., 2:49 p.m.,
Yes.
and that's November the 30th, 2021?
Yes.
So I want you at 2:48, right? They leave at 2:25. They have deputies there 23 minutes later. They arrive at the house, guns drawn, automatic weapons in their face, and watch what happens to Jennifer Crumbley, remembering that she is the parent who got in the way about less than an hour before, 20 minutes less, earlier. They're at the police station. There's absolutely no reason why they should be in handcuffs. They've come in, they've talked to the police, they've clearly shown that they're willing to, deal with the police, cooperate. If there was any reason to take him into custody or put him in handcuffs, they would have never let him leave the police station. But no. They do. But they don't put the dad in custody. So again, this is the problem here. This is the tell. This is how you can tell what's going on here. Because they were upset, as you could tell, they were frustrated with the fact that they weren't able to talk to the son. They show up at the house, full show of force. This is what it means when you're not cooperating. This is what it means when you assert your rights and you get an attorney. Watch.
And as we saw in the video, the shooter was taken into custody at 1 p.m.
Yes.
Okay.
Correct.
This one's just get the volume turned up.
Honestly, right now, we get those. Why is she in handcuffs? I don't know. Can you take the handcuffs off of her, please? Careful, you won't hurt yourself. Okay, plug in first. You guys can make it. It's not gonna be long for those handcuffs, I promise.
Why am I in cuffs though? It hurts, like it really hurts.
Wow, what's that?
Why am I in handcuffs?
I don't know. I asked them the same fucking thing.
They didn't do anything. I'm getting claustrophobic. I'm getting claustrophobic.
I mean, don't freak out in front of the cops. This is gonna be a lot better if you don't make the situation.
All right. There you heard it. Why is she in handcuffs? Look at him. He's not in handcuffs. She's in handcuffs. She's complaining that they hurt. They've been put on extra tight because they're making the point. You asserted your rights for your son. You got in the way of our investigation. So we have come to your house. We've raided your house. We've put you in handcuffs, and you're going to sit in the back of a police car for a little while, and we're going to make the impression. And even the deputies, like, they don't even address it. I watched the rest of this testimony. It's never brought up. It's never testified to why this occurred, but I think it's very clear why this occurred. Now, they do try to put space in between the knowledge of the guys that did this raid and the officers that were at the police station, although I don't see how you can. You're going to tell me that they didn't know a search warrant was being executed at the house of the Crumleys, that there was a communication that the Crumleys were at the substation? I don't believe it for one bit. I don't believe it for one bit. That might be what they say. Maybe it never showed up in a report, but I do not believe that you're going to sit here and make the case that this wasn't related, that the individual who's saying, I want an attorney for my son, she stops her husband from talking. Her husband eventually falls in line, as he kind of, I think, is typical in that relationship. And he says, okay, you're right. We're not talking. No more conversation until we get the attorney involved. There it is. So let's watch how this, plays out a little bit here. Watch how long this is. This is at 2:50 in the afternoon. She left the substation about 2:25. So you're talking about 25 minutes later. After they left, she's in handcuffs now. Her house is flooded with cops Watch the reactions. Watch as they're like, what is going on? He's sitting in there, and this is all meant to intimidate them, to send the message. He now says, hey, look what happened to your wife. You followed her. You didn't step up to her. You didn't say, hey, honey, we're talking to the police, or give us a moment, officer, let me talk to her. We're going to go ahead and waive the rights. No. So here we are. Your wife's now in cuffs. We're in your house. We've raided your house, and we're coming, and you now are against us. We are not with us. And of course, this is the search that they end up taking their cell phones, and they lose their personal cell phones. Again, everything, nothing, none of this, I believe, would have happened if they would have been cooperating with the police. They would have, I mean, maybe they would have been at the station and they might have done a cell bright, but the phones would have been able to be handed right back or relatively quickly. They would have signed off and they'd have been at the police station, say, yeah, we'll go down to your house and we'll search the house while you're down here. They would have got time with Ethan. They would have been able to talk to Ethan. They would have been able to hug Ethan. They would have been able to tell Ethan bye. But they said, nope, you get none of that. We're going to process him down. We're going to take his clothes. We're going to throw him in jail and go ahead home. That's fine. Or send the SWAT team down to greet you. And that's exactly what happens, because you're going to hear them talk about what happened, or at least I believe you will in this video. It might have been in another video that they had, but I believe in this one they talk about what they were doing just before that. They had, I guess, started boiling some water. I don't know for what for. And all of a sudden, James goes outside, never comes back. She comes out, she gets cuffed, and maybe that was in her testimony. I think that might have been how it was testified to. But let's watch a little bit more.
Why are they here? Why are they here?
At least they gave him a good song to listen to.
Okay, can you push my glass in my nose, please? Put chapstick on my lips, please. And then my fucking phone. I'm so confused.
Why are you in fucking handcuffs?
Your phone again?
I set it down and then I have a cop ready to go.
Why are they in our house? I'm so confused.
Oh, my bad. No, I was actually saying I think that we could have a verdict today. I think we'll at least get the Allen charge today if the jury comes back and says they're deadlocked, but maybe not. The Scott Peterson case went on for over a week, so they know this is a tough case. And very good point. It was another example of how the police twisted stuff. And yep, that's exactly who I was talking about. And thank you.
Where's your other gun?
In the gun case.
Where's that at?
In the dresser.
That's Patrick! Where's Patrick? Patrick!
He can't hear you. I love you in case something happens. If anything happens, you do not answer any questions without a lawyer.
Ma'am, I didn't catch your name.
It's Jennifer.
Jennifer, come on now, we hang, take the handcuffs off.
So, sir,
All right, so there you saw, right? Explain it to me. Why did they not have him handcuffed? They have two people sitting in the back of a police car. One's handcuffed, one's not. One was willing to talk to the police, one wasn't. One didn't step up to his wife. Well, he didn't step up to his wife, so he sees his wife in handcuffs. They pull her out of the car, and they move her to another car. They put her in that car with him because they wanted to drive home what was happening here. You don't commonly get two people in the back of a police car either. I mean, normally you would, I mean, that's almost unheard of that they would have put them in the back of the police car together like that. That was a purposeful thing that was done to drive home the message. You guys decided to not cooperate with us. We're now inside your house. We're searching your house. Jen, you're handcuffed. We're going full on you. We're sending the message. Now, eventually, there was other video that she gets up in another police car and has a conversation or answers some generalized questions. So the answer, why did this happen to the Crumbleys? Because they asserted their rights, because they didn't cooperate. As a result, they became a target of the investigation. As a result, the police became convinced, or at least to some level convinced, that they had some responsibility in this. They went forward with that line of thinking and that theory, and ultimately this thing flew out of control, and we end up where we're at right now, to where the state was forced to obviously take their case as they have in this case here, and try to argue and make a case that Jennifer Crumbley, James Crumbley are guilty of involuntary manslaughter. Now, had they cooperated, in the eyes of the police, they would have said, hey, they cooperated. That's the sign that these parents were good parents and not involved, because they cooperated. They helped us get their killer son off the street, and they didn't get in the way, and they didn't obstruct. But in their eyes, they say, you know what? This is a message. This is a message sent loud and clear to every parent across the country. If you attempt to assert your child's rights in a case like this, if you get in our way in any way, shape, or form, you could end up like the Crumleys. We're going to go through your phones. We're going to go through your life, and we're going to cherry pick little instances. And if your life isn't crystal clear, perfect, you're going to end up charged. You're going to end up with your life ruined. You're going to end up spending 2 years in jail, because the bottom line is, even if Miss Crumbley is found not guilty today, she spent 2 years in jail. She's lost her job. She's lost her home. She's had to spend thousands and thousands of dollars on an attorney. Not to mention, obviously, there's potential that, her and her husband could end up civilly sued. That's a whole nother issue, a whole nother situation. But ultimately, she has had her entire life upended, on top of what would normally have happened in dealing with the fact that your child was a school shooter, which normally would cause all sorts of emotional damage to yourself and possibly cause things like that to happen, but in a different way. But this is a message, loud and clear. Not only will you deal with the fact that your child did what they did, and that you're parenting, regardless of how you want to look at it, you parented that child up until the moment it happened. So, there's something obviously was wrong. But now you're going to be held criminally liable, and if the state of Michigan wins the argument today and the jury were to convict this lady, she could go away for 60 years. And that judge, because they tried the case, is more likely than not going to sentence her to 60 years. It's just when you take a case to trial like this, where there's 4 deaths, it's very likely that that's exactly how they're going to do to have to do it, or that they're going to sentence her to 60 years. But you saw why. And if you just joined, rewind the tape. I just walked you through what happened and why it happened. And I guarantee you, if they would have done what James Crumbley wanted and talked to the police, and you might say, well, they should have. Well, maybe they should have. But they also shouldn't be punished because they asserted their rights given to every single individual in this country. And the issue we have right now is there's a war on those rights. So we want to carve it out. We want to elongate it for certain situations. And there is no situation where the 4th Amendment steps down, where the 5th Amendment steps down, where the 14th Amendment right to due process steps down. Nothing, nowhere. There is not a moment that it should even be questioned. And the police are, again, remember, the police always are upset because, see, in order to investigate and respect those rights, it's more work, right? But here's the deal. We didn't hire the police, and the police didn't accept their job to investigate a case without the 4th Amendment rights, without the 5th Amendment rights. They took their job on to get an investigation done while respecting those rights of every defendant, of every person they're investigating, and to make a case in light of those, not in spite of those, not ignore them, go past them. Because their job is to uphold the laws, not break the laws. And when they don't respect the 4th and the 5th Amendment right of a defendant, they're breaking the law too. Absolutely, you're right, Eon Winstanley. They do not, and they have no money left. They have nothing left. And again, the state played this tape in the trial. They played both of these tapes. They put it out there. They want the message loud and clear. They understand that there's a good shot she gets acquitted in this case, but the point is, we want to make this abundantly clear to any parent out there that decides to step up and assert your rights. This is what you're going to do. We're going to destroy your life. And, you know, you inconvenienced us at a moment. You asserted something that was yours, but it's kind of like, you know, they don't want it to be yours because they want it to be something that everyone hesitates before you don't talk to the police. Yet you talk to the police, and you're going to talk to somebody who's taken trained interrogation classes to try to get you to potentially incriminate yourself, and maybe even say things that aren't true. And they're going to lie to you. They're going to mislead you, all because they're trying to say, well, if this person's guilty, then we say certain things that could get it out. Yeah, but the problem is what you said isn't true. So, you know, a lie, it's okay for you to lie, but I mean, you know, that's problematic. The reality is they should be out there, instead of trying to trick people into talking and playing tricks on individuals. They should be out there looking and investigating, finding evidence, doing it legally, doing it correctly, following procedure. And in this case, they had plenty of evidence, but it was just the idea. So what did they do? They went after him. Now, we're going to watch one final thing before we go into deliberation monitoring, and I have to step away for a little while. But we're going to watch the opening statements of the Miller hearing for Ethan Crumbley. And this is significant because this highlights the contradiction of this case. And I want you to listen to how the prosecution describes it. Now, they do address this contradiction, but they don't address it well enough. They just acknowledge it exists, and they're like, well, in light of it, doesn't matter. We can still do this. But I want you to listen to the description of Ethan Crumbley in this opening statement by the state. And I want you to consider and think to yourself the nature of these charges that the state put up. And in fact, you know what? Let's just put it up here. It's funny. Oh, hold on. 867. There we go. All right, so as we're watching this, let's let me screen share a different. There we go. Share. All right, so keep this. Oh, hold on a second here. I want you to keep this in mind as you're watching this clip. This is what they hold up. This is what they say, that there was a legal duty, that a parent has a legal duty to exercise reasonable care to control the minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. So in this, it would hold that the Crumleys had a legal obligation to control Ethan, right? So this would actually kind of say to the argument in a Miller hearing like this, that would say, well, Ethan was a juvenile, therefore he definitely shouldn't be getting life without parole, because his parents were supposed to have intervened here. They had a legal duty to intervene. He had mental problems. That wasn't done here. The theory of the theory of the state's case, right? The state is holding that they have charges against the parents, that they violated their legal duty, that there were mental problems here that were so severe and that could have been treatable. Because remember, that's another issue, is that they could have been treatable, right? They were treatable mental problems, could have got him help, could have done something, that they were so apparent and recognizable that it was inappropriate, even though they're living in an area where guns are part of the culture of that area, that the father should have known and said, no, we can't have guns in the house. And if they are in the house, they need to be under lock and key with biometric screening to get to them, because we have a crazy person in the house, right? So keep that in mind as we watch the state's description here. How do they get away with their argument here on why Ethan Crumbley deserved a life sentence? Obviously, I understand the emotional argument. I understand why parents in this instance might say, I would like to see him go to jail for the rest of his life. I understand all of that. But what we're talking about here is how the state can hold the parents under a theory that says that he has severe mental problems that were that the parents could have intervened on. But yet here they say, no, in order for them to get a life without parole, they have to say that he's so diabolical, that he lives in a completely different category than any other child in America, any other child in the world. And if he's that diabolical, then how in the world would you say that beyond that in and of itself is proof that there's reasonable doubt as to whether or not when Jennifer Crumbley or James Crumbley says, I didn't know. He seemed like a normal kid. That's the whole holding here. The whole argument behind the state here that you're going to see is the state is arguing that he was able to mask that he was diabolical, that he killed animals, that he did all these horrible things, and that the problem is that it's not a mental problem. It's just that he's an evil guy who can hide this. So even if he goes before parole board, he will fool the parole board. Well, if he could fool parole board, if he can fool school counselors, and if that's the argument of the state, then that alone is reasonable doubt to whether Jennifer and James Crumbley would have been able to foresee that their son would have done this crime. And I'm not a lawyer, so I don't know the ins and outs of whether or not you can play things like this in court. But this was something that was a statement that was made in open court. It's by the prosecutors that are standing in front of the jury. And I feel like it should have been played or brought up somehow. Probably, I'm sure there's restrictions against it. The state would have fought against it. But when you hear this, it's concerning. So let's listen.
This is very different from a trial that we are asking the court to consider allowing.
The courtroom court prior to. Thank you. That being said, any other preliminary issues from?
And it is important to believe.
It turns to my turn.
So the hearing today is just as important to these victims as it is to the defendant. And it is important to this entire community. Almost all of us have come to believe that a juvenile sentenced to life without parole should be exceedingly rare. And I believe that. I embrace that. I want to be clear that we acknowledge.
And I want you to understand, this is the prosecutor that did the closing argument on Ethan Crumbley. Okay. So in everything she's stating, she cannot state anything that she believes is a lie or dishonest to the court. So everything, we have to take everything she's saying here is completely what she believes. But yet she argues to the court again. Well, just listen.
Acknowledge that we bear the burden of proof and we have a heightened standard when we ask for a juvenile to be sentenced to life without parole. As this court knows, you must consider the mitigating factors set out in Miller versus Alabama, and we also embrace that. There has been a misconception that charging this defendant as an adult and charging his parents is somehow inconsistent. That is not true. They are charged for doing two different things. This defendant has already pled guilty to killing the 4 victims who died, shooting 7 other victims with the intent to kill them, and terrorizing everyone else who was at Oxford High School that day. He's the only one who pulled the trigger. The parents are charged with involuntary manslaughter for their gross negligence in buying the obviously troubled son a gun, for not securing it safely, and then for not doing anything about it when they saw the defendant's drawings on the day of the shooting. They are not charged for being bad parents, and no one is saying they pulled the trigger. What we're saying is they had an obligation to the students who died, and their gross negligence resulted in those students' deaths. Neither one of them gets a pass because of the acts of the other.
So, again, what you just heard was that was not consistent necessarily with what you heard in this trial, correct? The idea here was they put up evidence to suggest that the parents, and again, you just heard the crux of the case. They said it's all about what happened in that room at the school in ignoring that document. The problem is the state and the prosecutor should have said, wait a minute, counselors in that room believed that this was a cry for help for harming themselves or for harming himself. So to get around that, what did they have to do? They actually had to go and say they were a bad parent. She just said, we didn't say they were bad parents. Well, that's what you just spent an entire court case doing. You just spent an entire court case suggesting that Jennifer Crumbley was more interested in an affair than parenting her child. You just spent an entire court case saying that because they ignored, or in their eyes, they didn't address the messages of when they were involved in disciplining their son, and he wasn't getting his phone and video games taken away. Well, was claiming clothes were flying off the ceiling or the shelving and everything else. That yes, they were a neglectful parent there. So how does the prosecutor stand up here and tell the judge, we weren't saying they're a bad parent. We're just saying that they should have, if it's all about that sheet, then how in the world are the school officials not sitting there? If it's not about the parenting, Ms. McDonald, how in the world are the school officials? How is EJAC not sitting there? How is that counselor not sitting there? And again, she has an obligation to speak honestly to the court, and she didn't speak honestly to the court there. And then she came in a closing argument and absolutely spent an entire closing argument claiming Jennifer Crumbley was a bad parent, because that's what they were forced to do. Because when the defense attorney showed up and started asking questions, it's the only thing they could do. Yet here they come into this court wanting to go after him. Now, if they would have, see, the state, this shows you just how really arrogant the state is. They want to lock Ethan Crumbley up for the rest of his life. And the only way they can do that is they have to show that he is an extraordinary criminal, that he's gone to extraordinary lengths to cover up his crime. And essentially, the issue of parole or no parole is what they're saying is that he could trick the parole board. So they essentially have to say that his level of criminality and his willingness to hide his criminality rises to such a level that there would be no way that the parole board or mental health professionals or anyone would be able to see, to detect what he's able to hide. And that he did this at such a level because he said, I'm willing to be locked up for the rest of my life. I'm willing to go do all these things, and that it has nothing to do with mental health. That there's no, because if that's a mitigating factor that should have given him the ability to work on his mental health, seek counseling, get some assistance. But they didn't want to do that, and they couldn't do that in this case because, and again, that's why his case is up for appeal, because eventually the state of Michigan is going to get held accountable on some of this stuff because they're not going to get away with it. Somewhere, somehow, either this jury is going to hold them accountable in regards to seeing hopefully the issues that are present here and the contradictions that are present. And this is why it was so significant that they were already thinking down this lane of, where's Ethan Crumbley? You know, why isn't he here if these are such bad parents? You know, this kid's over here getting life in prison because he's worse than any criminal out there in terms of what he's able to do and hide. That he's the worst child in the entire universe, which is what they declare. How does this work? Anyways, here we go.
The defendant does not get a pass because his parents were grossly negligent. He is the one who researched and planned and carried out the shooting. And they don't get a pass because they gave their son a gun that he used, knowing he was a danger to use it. Each of them is only being held accountable for their own actions. It's important to be candid about what we do and do not know about this defendant. No one can tell us what he will be like in 40 years. None of us have a crystal ball, and we are not going to present any witnesses who will say there is zero chance of possible rehabilitation. No one can say that for sure. But this hearing is not just about the defendant's potential to be rehabilitated. It starts and ends with proportionality. The court has to consider the Miller factors, but also every facet of the offender and the offense.
I know.
And that's what
Well,
we will present to you in this hearing.
The manslaughter statute doesn't even
This is an offense
truly apply here.
unlike
They
any
stretched it.
other in this country or state has ever
It's horrible.
seen. Not just the number of children who died, but the way the defendant killed them, the amount of research and planning and preparation that went into it, and the way he carried it out. The picking and choosing of who would die. The video of the shooting doesn't have audio, but you will have no trouble interpreting the defendant's demeanor as he kills people and kids in that school. The way he walks up to them and fires at point blank range. The way he takes a shooter's stance in the middle of a hallway to kill Tate Meir. And this is an offender like no other. The video of the defendant torturing a 1-day-old baby bird shows that he is capable of a level of violence that most humans are not. And he takes joy in it. And he recorded it. The way he researched and planned the shooting, the way he thought through the weapon he wanted and how he got it, the way he researched and knew that Michigan does not have a death penalty, and that he stated over and over, I know I'll spend the rest of my life in prison. And one of the most extraordinary things that makes this defendant different than any other mass shooter in this country, as far as we know and can tell, is that he decided in advance that he was not going to kill himself. And he researched response times to make sure that he surrendered before the police arrived. And he did not because he wanted to witness. He stayed alive because he wanted to witness the suffering he created. When the United States Supreme Court and the Michigan Supreme Court talk about the rare case and the defendant, this is the one, Your Honor. Finally, we seek to present this evidence to the court in the most respectful way we can to the hundreds of victims in this case, the parents who lost their children that day, and those that are here with scars and bullet holes in their bodies. Your Honor, there is only one way to do that. It is painful and gut-wrenching, but the way to honor victims is the very same thing, Your Honor, that is essential to this court making its decision on whether or not this sentence of life without parole is proportional. Your Honor, this is it. We must tell the truth. Our witnesses must tell the truth, and they must tell all of it. We must have the courage and strength to listen and view the facts despite how horrifying it may seem. That is what we are called upon to do, and it is the only way to do so with the utmost respect that these victims deserve. Thank you.
Thank you. Defense?
Your Honor, if I just have one moment.
Yes.
All right, so there you have it. All right. She says in there, insanely enough, that we have an obligation to honestly present this, right? Well, if you're going to honestly present this, then you should honestly present the fact that, you know, if you're going to say that he's the most diabolical school shooter in history, he's so diabolical that he planned all of this. He planned his own way. He was going to survive this thing, and he planned times. And that shows you the sophistication of this child. So it is inside of that is all that is further proof beyond, further proof, further reasonable doubt of the fact that, guess what? These parents were not up against a normal child. So it's not unheard of that he was masquerading to them that I'm this normal kid because he wants to get away with it. And that flies in the face of this idea that he was exhibiting symptoms, which is what the state says. He wasn't exhibiting symptoms. He's not mentally ill. He's just a guy, a child, for whatever reason. We don't know. Maybe he'll get studied if this is if truly correct, that he's just somebody who had an innate desire to go kill people, or somehow it developed inside of him. Maybe it was video games. Maybe it was whatever. But he's this individual that is, that is the outlier here, who ultimately is, an outlier to the norm. And as a result, if he is that, then that alone is reasonable doubt for Jennifer Crumbley, or at least for whether or not Jennifer Crumbley could have foresaw this. So the state's staying, essentially arguing the case against their own case against the Crumbleys to get him life. And then they turn around and come to court and then argue that, no, the Crumleys should have known. And that, because remember, now, and this is the key part right here, okay? So I want to also, drive this home, because it may not be readily apparent to everyone of what I'm talking about here, and why you may say, well, no, they should have known. I want you to understand why these things are significant, why that's a significant fact here. And we're going to look at the key here. Yeah. All right. So looking at this here, the key thing here to understand is this language right here. And this is the key component here. And the state knows this is the key component. And this is why the argument that he is so beyond that he's an outlier. And this is why the argument in court that says he is the most extraordinary school shooter of all time is because in order to charge someone with gross negligence, you're not charging them with an intentional act. It's negligence. There is a component, this line right here. When to a reasonable person, it must have been apparent that the result was likely to be serious injury. If he himself is an outlier, then a reasonable person would not have foresaw anything. A reasonable person would not have looked at him, because what they're saying is he's extraordinary because a reasonable person, a reasonable parole board might look at him and be tricked, and that he tricked everyone because he was beyond the reasonable. He was an outlier. He's special because when this would have been within reason, he gets life with parole. But the fact that they're making an argument against that they say this is extraordinary, they cannot come back into court and say we have a reasonable situation that reasonable parents should have seen. And if it's beyond reason, then the fact that they argued for life without parole is the state acknowledging that this is beyond the reasonable, which is why I believe it should have been argued that this should have come in as an affirmative defense against the negligent argument by the state. The state cannot stand before a court and say, no, this is beyond any reason. This is such an extraordinary circumstance. We need life without parole, and then turn around and say, come back to this case and say, no, any reasonable person would have seen this. No, the whole purpose of him getting life without parole was because everything he did was beyond reason. It was not detectable by a reasonable person. It was extraordinary. He was an extraordinary criminal in an extraordinary situation. Now, let's go look at the causation. And this, again, was put up by the state itself. So here we go. Again, is there any reasonably foreseeable? So again, was it reasonably foreseeable? The state says no. The sole reason why nothing was reasonable about this case, that he was an outlier, that he was such an extraordinary criminal. He went to extraordinary lengths to hide the detection. He went to extraordinary lengths to keep himself alive. He looked up police reaction times. He's killing animals and his parents don't even know. He's this extraordinary, sick, sadistic killer who wasn't mentally deficient, who was just an intentional individual that can never be cured, because what they held out in that hearing and what the judge found in that hearing, and because it's now a matter of fact, because it was found by a court, it should have been, in my opinion, again, I don't know, I'm not a lawyer, so I don't know how it would get in, but a good lawyer, I would have imagined, could have figured out a way to get it in and said, hey, the court made a finding of fact here that this individual, that in order for him to have found this, he found that this kid was beyond the norm. And as a result, by definition, the state themselves has already said nobody could have reasonably saw this happening, because this kid didn't put on the normal signs. This kid was beyond the norm. And don't take my word for it, because I'm defending Jennifer Crumbley. Take the word of the judge who made the finding. Take the word of the very prosecuting attorneys that are sitting in that courtroom arguing that. It's not this is not the defense putting this up. This was the state holding out that Ethan Crumbley was extraordinary. So extraordinary to deserve life without parole. And the judge agreed. And then the state rolls in and says, reasonable person could have seen he was going to do this. Reasonable person could have. No. Well, reasonable person obviously couldn't, because they made the argument that he can trick reasonable people. That alone is reasonable doubt. It's done. And if the jury should be able to consider that, because that's evidence held up in court as honest, true. Because if that's not true, okay, and they convict his mom, and then the state has held up, the state's creating an issue that could potentially unlock an appeal for him and maybe get him parole one day. State can't have their cake and eat it too. It's either lock him up without parole, let the parents go, or lock the parents up, and now you can get reversed on appeal potentially because his attorneys are frothing at the bit. That's why they were asserting their rights. That's why they were keeping him out of there, because they wanted to because they know if the parents get convicted in this case, the state has a problem on their hands, a big problem on their hands, and this should be a problem that should disturb everybody because of how they've handled this and charged this case and went forward. And as I showed you, they didn't do it out of a true sense of wanting to get justice for anyone. They were mad and pissed off and angry because these parents didn't cooperate. I showed you the footage. They made it clear. They told on themselves because there's no explanation for why Jennifer Crumbley was in handcuffs in the back of a police car and her husband wasn't. When 25 minutes before, or maybe 45 minutes before, she's the one that interrupts her husband from telling the police information that the police wanted. She's the one that jumps in before they can sign the waiver to let the police talk to Ethan Crumbley and says, we want a lawyer. She's the one that asserts that she's going to have, well, they don't know who the guy was, but it turns out it's her boss. And she says, my boss is Andy's going to help me get an attorney. We're going to have him. She's the one that turns the husband against talking. The husband then asserts himself. Police are expecting like, hey man, you should have, you should be stepping up to your wife here and saying, listen, this is, they try to give him the reason. They try to feed him the argument. He doesn't bite. They go in, they try again. They put him in front of Ethan. They say, we really, they speak and load it up and say, hey, listen, we were going to ask you all these questions. We were going to find out why. We were going to get into all of this, but your parents have decided they want to get you an attorney. So we can't speak to you. And Mr. Crumbley doubles down and says, all right, I'm going to speak up, man up, because my wife has made it clear what her wishes are, and I'm going to abide by them. And then at that point, they say, okay, that's fine. We're done here. Get out. And we'll take you down, Ethan. And they go over the long and hard of it. You're going to get taken out of your clothes. You're going to get thrown in a jail cell. You're going down to the jail. And yeah. And then they go in the room and the parents are crying and they're like, hey, sorry. Yeah. Be in touch 1 to 2 days. See you later. 20 minutes later, SWAT team's at the house. Jennifer Crumbley's being taken out in handcuffs. They're put in the same police car, which is a little strange. Clearly, they want to see him talk, but clearly they want to see the impact of, hey, James, look, your wife's in cuffs. You can see the reaction. Why is my wife in cuffs? Why am I not in cuffs? Well, I think we know why. And then they take their phones. They go through their life. They cherry pick, and they say, you know what? You want to search your rights? We're going to make it clear what happens when that happens. When you don't cooperate. And they find just enough to make them look bad. They find out about sordid affairs, and they find some messages that they can stretch and turn and twist. And they basically rip apart these people's lives because they say, you know what? You decided to stay on the side of your son. In fact, in my opinion, the fact that they asserted his rights demonstrates that they were caring, loving parents who cared about his future. It also demonstrates that if they would have had any suspicion whatsoever of a school shooting, that they would have absolutely done something about it, but that they didn't, because they didn't think that's what they were dealing with. The culture of the area is guns. The father was a gun enthusiast. He thinks he's doing something with his son and bonding with his son. Neither of them had any inclination that their son was planning to go shoot up a school. They arrive at the school that day. The counselor at the school is immediately telling them, we got a situation where we need to support Ethan. We think he's suicidal. We think he's going to harm himself. Let's coalesce around him. We're going to give you some support. We're going to give you counseling options. They talk about what the best route is for the rest of that day. What do they want to do? Are we going to suspend him? Does he need to leave? And they say, no, it'd probably be good for him to be around his friends. Does that counselor want to own that? No. Does EJAC want to own that? No, because once the shooting happens, everybody wants to get away from him. And then the issue at hand is, again, that is the sole situation. But if that was truly a negligible situation, if that was truly a situation that rose to the level of gross negligence, then this counselor should have been in there, because it should have been, again, the key definition here, it should have been evident to a reasonable person. You're not going to tell me a counselor wasn't reasonable. And then if you're going to sit here and make me believe, I don't believe we're one bit, if given the fact that these guys are in that community, that if they would have brought up and said, oh my God, yeah, he just got access to a gun, or not access, but we just bought him a gun to be going to the gun range, it would have all been being thought not in the vein of a school shooting. It wouldn't have changed one thing. It would have just said secure that and keep it away from him. I don't think he should be giving that to him right now, because he could harm himself. And we need to get him to the counselor. We need to get him intervened. And what parent is going to think 7 months ago, my kid in the middle of a disciplinary issue where I took his phone away and video games away and wanted him to clean his room, that he's decided to tell me that there was the reason why my room's a mess is because there was a poltergeist. Who's going to think I'm going to go down and get I'm taking my kid? I mean, in fact, if you probably took him in with that little bit of information, the ER is probably going to say, man, call this hotline and get him into someone. But I don't think we have a crisis here that's at the level of locking him up. Given my wife's a mental health nurse, I haven't posed that question to her, but I probably should, because she would have dealt with kids. She deals with individuals in situations like what the Crumbleys would have been dealing with on a daily basis. Kids get admitted in, but I just don't think that what those messages were and what those parents saw, that there would have been really much done about it, because it would have really been looked at as a disciplinary problem. And having talked with her, not about this specific situation, but talked about situations and things and how things get viewed, you need far more than just, hey, tell me the circumstances. Well, my kid, he's having grade problems. He's having some issues with us. We took away his video games. We took away his phone for a little while, or restricted him on what he can do on his phone a little bit, and made him clean his room. And then he started texting and saying there was a poltergeist in the house. That was, oh, really? Yeah. Well, has he ever said he's heard voices? Well, no, he hasn't. We know that because he told his friend he hadn't told his parents that. And he was saying, I think I might. And then, he's requested to see a doctor because he says he's upset because I guess and they would have been like, okay, well, it sounds like your kid, isn't liking being punished. It sounds like he's trying to get out of some things. Maybe we'll set you up with a counselor, let him talk to somebody. But is this a crisis? Is anybody going to come to the conclusion and be like, oh, ma'am, thank God you brought him in because you saved a mass shooting from happening? No one's going to think that. Not with this set of circumstances. It's absolutely ridiculous. And the state only came to those conclusions because they already saw that it had happened. They had parents who weren't cooperating. They were mad at the parents. They didn't like Jennifer Crumbley's attitude. They didn't like her demeanor. And then when they get in her phone, they didn't obviously like her lifestyle. And they thought, you know what? We're going to go after them. And then when they found out that they had bought a gun and that she was on Instagram showing off her gun, they thought, you know what? This woman, no wonder they didn't want to talk to us. No wonder they didn't want to sign the rights away. They knew they were neglectful, but the problem is there wasn't any evidence of it. They just wanted to assert their rights because that's what you're supposed to do when the police are knocking on the door and your kid's facing the rest of his life in prison. And they just wanted what every person should do in this instance. And if you watch any interrogation videos and you listen to any of the police officers or defense attorneys out there, or attorneys in general, you talk to my dad, who will tell you, absolutely, you ask for an attorney and you have an attorney present. And the only reason why the police don't want an attorney present is because it's going to be less likely that they're going to get away with lying to the defendant. They're going to get away with getting him to take a polygraph and lying to them about the results. They're not going to be able to employ all the tactics that they want to. And it's going to be a fairer conversation where this individual is going to be aware of each and every right that they have and it's going to be administered. And my issue is why are the police so afraid of that? You're supposed to be administering and protecting, and part of protecting is not just protecting against the criminals and the bad guys, but it's also protecting your rights and respecting your rights and being that example in every community to show that, yes, we protect and we respect your right to remain silent. We protect and we respect your right against unreasonable search and seizures. And we will only do those things if you waive your rights, and you waive your rights knowingly, and you waive your rights without any coercion, without any manipulation. Then we'll have a conversation with you. And if something comes out that's against you, and you decide at some point you want to have an attorney present, we'll happily bring an attorney in with you. And if we don't have a probable cause to search your house, we won't. We're not going to create it. We're not going to play around with it. We're going to respect and protect your rights, because it's as important to do that for the potential accused individual as it is for the victim of a crime. And we're going to try to get this thing done so that we know when it gets to court, there's little question as to whether or not procedurally there's issues. And then when the prosecutor takes over, we're going to make sure that the due process rights of the defendant are respected and protected. And we're not going to leave any question about that. But in this case, no. The police were upset, and they wanted to send a message, and they have sent a message. I think any parent watching that and sees how they held it out and sees how the prosecutor basically attempted to use. And that's one of the reasons why, I guess maybe I missed the argument, but I would have made an argument that, they were essentially the state. How that got in, I don't know, because it seemed to me that they should have edited the video out, because you can't, or at least there should have been an instruction, I believe, something along the lines to make sure that the defendants asserting their right to an attorney should not have been held against them. And I believe by showing that video and having that in there, that absolutely had that effect. Now, that's obviously an appellate issue. Maybe she's found not guilty and it never gets brought up. But I'm not an attorney. I just see these things. I recognize things as issues that I've read before and seen my dad talk about and seen in other cases come up. But it strikes me that you absolutely cannot, just like you can't, it's improper to have someone take the fifth. It's improper to see to have that played in the way it was, to where it was insinuated by the police officers that they were somehow hindering an investigation by asserting the right to counsel of their son and themselves. That is an absolute right that should never be held against them for having asserted it. And by playing that video in open court, and the state did that, and I don't recall there being an objection. Maybe there was. It was already discussed in pre-trial. But of course, there's the issue of preserving. And by not having seen that issue raised, I did not believe I saw that objection, although it might have been raised, and it may have been a prior objection raised, which is why it got played, and it may be encapsulated in prior objections when other videos got played. But to me, the way it was presented there, it was concerning to me that the inference could be made, because there was really not much evidentiary value to that. The only evidentiary value was, and again, they should have been able on a very limited basis to have played the portion they wanted, which was we could have never known. But they asserted that they wanted an attorney. So they shouldn't have, and the police just traipsed past that. So to me, that statement should never have been used against them. They very clearly stated they wanted an attorney. Now, again, I assume that was fleshed out probably in a hearing I didn't see. But that's a concern. But the state brought it in and put it on display. And we can see that now. We can see the causal link between their assertion of rights. 20 minutes later, they leave the police station. SWAT teams at their house. Handcuffs are on mom. All hell's breaking loose. Dad screaming about, what the hell? Why is my wife in handcuffs? I think we know why. Then you have, again, to further pound home the bad faith of this case, You have the same prosecutor at the Miller hearing arguing that Ethan Crumbley is an outlier, is like no other school shooter ever in this country. That he is so extraordinary, that he's so diabolical, that he went through levels of planning, and yet the same prosecutor returns to this courtroom, or I don't know if it's the same courtroom, but returns to court prosecuting the mother under a theory of negligence that requires reasonableness, requires that a reasonable individual would have thought, yeah, my son might be mentally troubled. It might be a bad idea that he might be wanting to do a school shooting here. Yet they argued, no, nobody could have detected this. No parole board. That this guy is so diabolical, so conniving that he would fool a parole board. So he's not eligible for parole. He would fool doctors. He did fool a licensed counselor at the school. But apparently the Crumbleys, hey, they should have been able to reasonably detect that their son, being this super criminal that the state has alleged. And again, this is the conflict the state has created. And in my opinion, that should have somehow been able to have been brought up and brought in, especially when you have the same prosecution team sitting in that courtroom making the arguments. And because they have an obligation of honesty to the court, that is a concern. And that should absolutely be an issue that's raised at some point, I believe. But again. All right. So let's check out what's going on in the court right now and see if there's any movement in the court. All right, guys. So as you can see there, no movement in court. I went back and I was looking there before I came back on here live just to see if there was anything going on over at Law and Crime. Does not appear to be any reports. Nothing on Court TV. Nobody's reporting anything. So it appears we're moving into hour 10 of deliberations. So I guess, if some of you are joining in, rewind the tape. Go back to the beginning. Just had I guess hour and a half long, hour and 45-minute discussion on the case, getting into why they charged the Crumbleys, the real reason. We played back some important pieces of tape that gets into that and pounds that home. Discussed the Miller hearing and the contradictions that it creates for the state and the dishonesty of the state in this case and how they presented that case versus how they presented the case in this court and the implications that might have for both of these individuals on appeal. If the Crumleys are acquitted, it's still going to raise fertile ground for the way what the state's arguments were. And we have to, as I explained, because any statement made by an officer to court is assumed to be, there's an obligation of honesty. In this case, we have a problem where we literally have, I'm surprised that they had McDonald arguing both cases, but she makes the opening statement in the Miller hearing. She makes the closing argument and opening statement in this case, and she's essentially contradicting herself in the sense that in the Miller hearing, as I said, he's a diabolical criminal. That's an outlier. That's unlike any other school shooter in history. And he comes into this and says, no. He's not that outstanding. This is a situation where any reasonable parent would have looked at this facts and been able to detect that what he was up to. Well, if that was the case, then he should be getting 25 years to life. And he should have the opportunity for parole in 25 years, because that defeats the argument of him being unusual and being such a criminal in a class of another and being undetectable. Because what the issue against parole in the case was, he will fool the parole board that there's not a mental issue, that there's not a redeemable quality about him, and that there is no way that with any type of counseling or rehabilitation that he will ever be able to overcome what caused him to do this. And that was just evil, and a diabolicalness that is at another level. So, you can't make those, you can't have your cake and eat it too. And the state, I believe at some level here, is going to get brought to task. Oh, saw a head come by. Maybe we will have a verdict here soon. I don't know. Could just be somebody walking by, but that could be indicative that somebody's walking back in the courtroom. Let's check a source here. And interesting here, I just went over and looked at the law and crime poll, 20,000 votes, and 56% of the respondents in that poll believe it will be either guilty or not, or believe it will be either not guilty or hung jury. Only 44% going guilty. And I'm telling you, that is a strong indicator. Tyrone Tucker was 50-50, and that ended up hung. There was a lady that ended up running over her husband. This was the first case I ever covered on this channel. That was like 60% guilty, 40% not guilty, hung jury. That ended up being not guilty. It's a strong indicator when only 44% of the viewership out of 20,000 votes are guilty, that reasonable doubt exists in this case, and that 12 jurors back there are going to go towards not guilty. So, strong indicator there. I believe it's not obviously anything empirical or completely reliable, but it appears I do not see any indication that anything is happening at this point. So, so essentially what I'm going to do here, guys, I'm going to turn it over. Feel free to chat in there, leave me a thought. I will be monitoring the chat. I've got to step out. It's that time of day where I have to go pick up my son from school, and we'll run some errands and things. So I may watch, if the verdict were to come back between like 2 and 4, I'll be experiencing it with you in chat, watching the live feed, provided that there's no interruptions. And otherwise, if it comes in after that, or they decide to go into evening deliberations, I'll be monitoring the feed. I'll come back in. I'll talk to you. As I mentioned yesterday, my live will cut off in about at the 6-hour mark. So I've got about 4 hours left. So at about 5 o'clock, a little after 5, it'll cut off automatically. I'll have to refresh it. So I'll obviously come in and do that if I need to. Although I think the way this judge is doing it, I think she'll end court at about 4:30 is what they did yesterday. I have no reason to believe they wouldn't do it today. And then we'll be back for day 10. Um, oop, just realized I never changed that over. Hold on. All right, guys. Well, I will talk to you soon. Apologize, I had to go out and reload there. Apologize. My sound was off. So apologize, I had to go out and reload there. Apologize. So there is a verdict, and I'm being told it's going to be announced imminently. So we shall see. We're finally going to get to see exactly what the discussion was. Was this a discussion in the jury room because there was one or two not guilties and they had to bring them across, or was this, as many people are believing or would believe, that this was a few people wanting to find her guilty that they had to bring across? So here we go. And this is a historical verdict because the implications if a conviction occurs are going to be a pretty large for parents across the nation. But we'll see if the state was successful in arguing their case. I feel it's going to be not guilty. Obviously, I think everybody can tell that from listening. But I assume they're going to be, that means they're bringing the defendant in, given that's a bailiff. And now they've got the bailiffs in the courtroom, so I would assume they're bringing the defendant in unless she came in during the break in transmission there. I always find it interesting when you're watching a verdict, especially live. Like, it's the closest that individual who's been locked up, especially if they're either unable to make bail or without bail.
Recording in progress.
Technically speaking, in a couple of minutes, if it's a not guilty verdict, she's walking out with the rest of the spectators and the lawyers, and she's going to get to breathe free air for the first time in 2 years. And then, of course, on the flip side, she may be right back where she was 20 minutes ago, except this time now she's sitting there with the realization that she's going away. Oh, I think definitely it was probably, probably 8-3 or 8-4, or maybe 9-3, starting out on one side or the other. But I'm going to believe that some people would say, well, the question yesterday about the inference, can we infer, that could be taken two ways. That could have either been like, there's 2 or 3 people that were saying, hey, he didn't testify, I think it's not guilty, he should have come in, and the guilty people are going, you can't consider that. So they come out and they pose that question. That peels away another one. So now you're, or it could have been, the guilty person is saying, hey, there's a bunch of people in there saying, hey, that they're wondering about it and saying, well, I think that, he didn't do this, and the guilty person saying, well, you can't consider that, and they come back, and that further deadlocked them a little bit. But, I don't know. I would imagine she's definitely shaking right now because she's got to be, like I said, right now, when this court goes in session, if it goes not guilty, she walks out. Part of the nightmare is over. She's eating a regular food for the first time. She's enjoying free air. She's looking at the sky. She's getting to do normal things again, as normal as her life can be after something like this. I know I always get a little nervous, especially with a case like this that just has severe implications about how, for parents across the nation, and how things will be handled. Because if the state succeeds in this case and gets four guilties here, they won out on emotion. They showed that, in essence, in my opinion, the jury system didn't work. Because it is cases like these where you have overreach by prosecutors that the curative thing to do here is to have a jury come in and find her not guilty. Probably not. He's over at the jail. But because he won't know anything until he sees the news. Now, he could be tipped off. You know, maybe a correctional officer would have said, hey, your wife's verdict's about to come in. But he won't find out until it hits the news. And then, because a lot of times they play the news or now, I don't know. Some jails today are providing tablets for their prisoners. So it's possible that he could be, you know, not watching it, but that he could be looking at news clips. Well, his lawyer will probably tell him as well, because I think that he's due to go on trial on March 7th, either 5th or 7th. I can't remember. I think it's the 7th, but he's going to go. I think it's actually the 5th. Actually, I have to look that up. But he's first part of March. He's supposed to go to trial. So his defense team will definitely be watching this closely. But do not believe that because she's acquitted that he won't go to trial. He's going to go to trial, because remember, it's just that if she's found guilty, they will feel more emboldened than ever, and maybe he'll take a plea instead, because the weaker set of facts were for her, because the core of the allegations against her were her failing to act on that worksheet. Whereas with him, remember, there's two theories of how they can find it. There's the failure to act with that worksheet being in front of her with the drawings, and the knowledge that he had just had a gun, that there is access to guns in the house, etc. And then there's also going to be, for James, as the owner of the gun, if they have evidence, and I don't know if they do or don't, because there could be evidence that comes in against him that couldn't come in against Jennifer, there's going to be the question of whether he secured the gun, and if he didn't, as a gun owner, if he didn't take steps to secure the firearm in the house and it gets in the hands, it's not a matter of school shooting. It's, does the hands in a gun of another potentially could result in the death of others? And yes, it would be reasonably presumed that that could be the case. With Jennifer, because there was really no evidence that she had anything to do with storing the weapons or having anything to do with that, that was a very, very weak case. And I don't believe the state would have reached any juror beyond a reasonable doubt to think, yeah, you would get her on storing that firearm or keeping that firearm away from him. It would just be, she knew there was a firearm potentially available. She's at the school. Again, that's why I said with Jennifer, it's a really difficult case. So I'm inclined to believe it'll be not guilty for her. Much easier not guilty for her than it would have been against James, which is also the interesting fact of why James wasn't in handcuffs in that police car and Jennifer was. There's one reason. Because Jennifer was the one who asserted her rights and the rights of her son. And she was the one that set this in motion as becoming an adversarial situation for her and her husband. And there's the prosecution walking in. People are shaking hands. Let's see what the demeanor is of the defense attorney. She's got to be nervous, I would imagine, because if she wins this case, I mean, that's going to be a huge feather in her cap. Not to mention it's a victory on the right side of the law. So, and of course, having been the target of a lot of criticism, I'm sure she really wants a victory here, just to say, you know what, everybody that thought I didn't do a good job, everybody that thought I was too emotional, everybody that thought I was, you know, not capable of winning, look at me now, not guilty. In a case that, so I think once we see her come into the courtroom, we'll know that the verdict is imminent, because they're not going to bring her in until they know they're ready to get out here. It's a shame you can't see the jury, 'cause sometimes the jury will. I think this jury is going to have the verdict all over their face. I hope the jury does proper justice. I do. Oh, I think it's her. Here she comes. Nope, that's not her. False alarm. Oh, okay. There it is. Bringing the client in. So it looks like our poll is 4 votes, 50% not guilty, 50% hung jury, no guilties here. So I think we know where we got only 4 votes on our poll, but that's okay. Let's see what Law and Crimes poll's at right now. Oh, they took their poll down. Wow. Well, I see a lot of not guilty, though, in the chat. So I just cannot imagine this being a guilty verdict. Not with the amount of people out here seeing it as not guilty. It's just unheard of that a jury would come back, that jury box would have been tone deaf to the degree that people out here watching, not even watching the full trial. But I suppose maybe they saw something we didn't. But I just feel like the lengthy deliberations, the weakness of the case, the question that they posed yesterday has to be not guilty. Oh, I bet they are. Because it's an interesting case because again, this is a case that is I don't know what the circumstances they're talking about it under, but it's a case that absolutely has some implications over our justice system and the administration of justice. So we have a guilty in our poll. So somebody jumped in there and took the 0% out. So we got 1 of 5 believe it's guilty. We're going to transfer the hung juries over to not guilty because if they believe it's hung jury, it means they can't decide. We have to assert reasonable doubt there. So we're 4-1 not guilty right now by my reading of the poll. If you're just coming in, make sure you vote in the poll. We want to try to get as good of a read on things as we can. And we have Jennifer Crumbley. We're getting one step closer. Well, Jolo, a just verdict is a verdict that is followed by the law. And in this case, the law, in my opinion, they failed to meet their burden. So, now, whether or not that is satisfying for people out here who are upset and believe she was an inadequate parent, there she is with that chapstick. My God. I noticed that in all of the videos. Those parents were putting it on each other every 5 minutes. I don't know what their deal was with chapstick, but they have a absolute addiction to it. She was even at the defense table after months in jail. I wonder if they have it in the commissary there, because if they don't, my God, I don't know how she would survive. But I think a just verdict in this case is if there's reasonable doubt, and there is, and the evidence is weak, that's a just verdict. It might not be she will be held accountable in other ways. But the issue here is there was not a law on the books to deal with this particular situation. And they attempted to apply a law that already existed in a creative way to try to charge her. Now the father, like I said, it's a different situation, but they're really, when you look at this entirety of this case, there was no evidence that she ever had any responsibility or knew that the gun wasn't secured. It was 3 days before that she was at the range, and her knowledge was her husband took the gun out of the car, so that eliminates the whole gun issue of that gun being out and not secured. The sheet, again, from a reasonable perspective, was it reasonable to look at that sheet and think he was going to do a school shooting? No. They cherry-picked 2 incidences where there were cell phone messages. She gave an explanation for what they were talking about. That's further bolstered by the fact that there was nothing else discussed for 7 months. All of the discussions he had with his friend were done away from her. There was no evidence that she knew about them. The kid that he was talking to didn't feel inclined to tell his parents or tell her. So there's no evidence she had knowledge of how her son was feeling. And then the idea here, we put some arbitrary standard in to say, well, she should have been asking her son or she should have been inquiring of her son. Okay, what's the standard of that? And then on top of that, the state itself answers the question of reasonableness when they argued for life without parole by saying he was a criminal that was of such
All rise. Court is now in session. The Honorable
unusualness
presiding.
that he deserved to get life without parole. All right, here we go. Oh, no problem, Joel. Verdict time. Here we go. And I'll shut up while we get the verdict.
Your Honor, calling People v. Jennifer Crumbley, case number 22279-990, FH.
Good afternoon, Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
Good afternoon, I'm Shannon Smith on behalf of Jennifer Crumbley, who sits to my left.
All right, are you ready for the jury?
Yes.
Yes, Your Honor.
All right, I'm going to ask when the jury reads their verdict. After that, I want everyone to remain seated. All right.
Judge, do you want us to sit up? Stay standing or
It's up to you. It's up to you. I really want the audience to stay seated after when the verdict's read and after that. And it's okay.
Maybe she's got word that it's going to be not guilty, because that would mean that maybe she's worried about how the audience will react. I hope they do. I hope they do, Jolo. I absolutely hope they do. But I think it's interesting that judge is so worried, because if it's a guilty verdict, this audience isn't going to react. But if it's a not guilty verdict, they would. Let's see what's up.
Good afternoon, you may be seated. Ladies and gentlemen, I've been informed that you have a verdict. Is that correct?
That is correct.
Are you the correct person?
I am.
All right, here we go.
The verdict.
Individually?
Sure.
Okay. On count 1 of involuntary manslaughter as to Madison Baldwin, we find the defendant guilty of involuntary manslaughter. On count 2 of involuntary manslaughter in regards to Tate Muir, we find the defendant guilty of involuntary manslaughter.
Wow.
On count 3, as to involuntary manslaughter regarding Hannah St. Juliana,
Okay.
we find the defendant guilty of involuntary
Wow.
manslaughter. And in count 4 of involuntary manslaughter against Justin Schilling, we find the defendant guilty of involuntary manslaughter.
Wow.
Thank you for a woman. You can be
Wow,
seated.
wow, wow.
I'm going to listen to all this.
Well, man,
Jury in seat number 2.
Shocking.
Is that your verdict?
that is
Jury
shocking.
in seat number 3. Was that and is that your verdict?
Yes.
Jury in seat number
Man.
4. Was that and is that your verdict?
Yes.
Jury Jury seat number 6, was that
Mm.
and is that your verdict?
Yes.
Jury seat number
Mm-mm-mm.
7, was that and
That
is
is
that
a
your
shocker right there.
verdict? Jury seat number 8, was that and is that your verdict?
Wow.
Jury seat number 11, was that and is that your
Woo.
verdict?
Yes.
Jury seat number 12, was
That's
that
a
and is
shock
that
right
your
there.
verdict?
Yes.
Jury seat number 13, was that and
Mm-mm-mm.
is that your verdict?
Yes.
Jury seat number 14, was that and is that your verdict?
Yes.
Jury seat number 16, was that and is that your verdict?
Yes.
Thank you very much, ladies and gentlemen. We all know that this is one of the hardest things you've ever done. I'm going to ask you to return to
Wow.
the jury room. The two remaining.
Oh, absolutely there will be appeals. Absolutely there will be appeals.
Thank you.
I mean,
All rise for the jury.
there's a whole slew of appealable issues, but that doesn't change the fact that, I mean, that's not what Jennifer Crumbley wanted, and it should have been a not guilty verdict today. I mean, it just should have been. I mean, I understand this jury ruled on an emotional basis. Clearly, we now know that question was aimed at the jurors back there that felt she shouldn't be convicted, and there was obviously some assertive jurors back there that were. I think Jennifer Crumbley is in shock,
9 o'clock is fine, thank you.
and you can tell the defense attorney is in shock. I mean, this is a chilling verdict
All rise.
that the state got away with what they did in this case, as I have mentioned, and we talked about for the first 2 hours of this show today. 83% of our polls right now, only 6 people. But remember, law and crime today was
Come here. Come here, go ahead.
and we're just watching the reactions in the courtroom, specifically the attorney there, Shannon Smith. Absolutely, they did not go with the evidence here. They had clearly, again, they had people back there that were, and those parents reaching across. I understand they lost kids. What they've done here now is unbelievable. And hey, I already have kids, but let me tell you, man, people are not going to want to have kids after this, because this is chilling what they accomplished here, and people don't realize it. And we've, for the first time ever, I mean, in my opinion, we can only hope on appeal. We can only hope. Hold on. I think my camera cut out again. Oh, no, there it is. Never mind. We can only hope that on appeal, this is rectified. That's it. That's what we can hope for right now. Sad day there for many things. I know that wow. It's just unbelievable. Unbelievable. But it is, I mean, that is the verdict they choose to come with. You got to respect the verdict. But there was a lot that happened in this case that's ripe for appeal. But that's what we're gonna have to deal with here. Wow. I mean, what a shocking verdict. What a truly shocking verdict. So, from my perspective, I just, wow. And having watched this trial and seen the evidence, I'm truly concerned because, I did not believe that the attorney was a bad attorney at all. Oh, the verdict sets a terrible precedent. Absolutely. This is horrific. This is terrible. This is people, again, don't fully understand the implications of what occurred here, but you had almost, in a sense, reverse jury nullification. Well, I don't know if you could call it reverse, but it was almost a jury nullification verdict for the fact that the state had no case, came in here, flooded the gate with all sorts of horrific videos, got in the minds of some people in there that clearly were like, I don't want to walk out of here. She's a bad parent. She had an affair, and they were judgmental of her and went ahead and said, yeah, but I mean, how the jury could have come to this verdict, believing that she should have reasonably foresaw a school shooting was going to occur with what happened here. It's ridiculous. It's ridiculous. It's absolutely ridiculous. Well, yeah, I think that she might have checked the forms, or I'm sure the forms will get checked, but provided, unless there's a mistake on the forms, but maybe, maybe they, maybe it was not guilty, but I think that I didn't hear, maybe I'm mistaken. Maybe I am mistaken in the sense that, yes, we will get, well, yeah. You know, maybe they were, maybe I'm mistaken, but I don't think I even heard the jury get polled either. I think Shannon Smith was in shock, and I think she's going to feel like, obviously with the intense criticism that came her way, I think she's going to feel like maybe she was a bit to blame here and how she presented her case, and perhaps, you go back and you look and you think, was that part of the problem? Was she an unlikable advocate? Because this case solely is about likability. It's not about evidence. It's about them flooding the box with imagery and hate for her, and then getting them to interpret things in that way. And wow, just absolutely shocking. But appreciate everybody that watched. But like I said, I'm not going to obviously keep the stream going now since we have a verdict, but a shocking verdict. I'll give more analysis on it. I'll come back. I've got to settle in and give some thoughts on this. But I guess we'll be back in March to watch. We'll definitely be watching James Crumbley's case, see how a jury sees his case, although I could see him plea bargaining now. But I would implore him not to, because I still think that, that a different jury could come to a different verdict on this. I am just stunned, speechless. Horrible day for our justice system today. That's what I believe, at least. And if you don't agree, that's fine. But I think anytime we have a jury come to a verdict that isn't supported by the evidence, but again, we have to respect the verdict at the end of the day, and that's fine because it's part of a process. So the beautiful part about this is this, and again, it's a tough day for the justice system, but it's actually also an opportunity too, because now we will see the repeal process, and this is a case that you're going to see why it's necessary to have every part of the process work, because the trial took place under the precedence of the pretrial rulings and the evidentiary rulings and the things that were allowed in. Now, appellate lawyers are going to be able to come in and review this, and it's going to absolutely be of the utmost importance that they do. And now we're going to get to see what will be, in my opinion, a very exciting appeal. I'll be watching. I hope they air the arguments when it undoubtedly makes it to the appellate court in a couple of years. I'll be interested to read the briefs, bring them to you, or read it together, because I think it's going to be flooded with tremendous legal issues. I'll be interested to see if there's a due process challenge here of this case, because I believe there's a definite due process issue in the way they could attempt to construct the carve out of the law, and the issue being that it opened it up for too much vagueness. It was impossible for a jury or anyone to understand the standard, and when you put that before a jury, essentially it made it ripe and open for an emotional verdict, because otherwise, how else do you define how to get to guilty? And that's what happened in this case. So we'll be covering all of that. Next trial, I'm not certain. I've got to figure out what trial we're going to jump into next. The Draconis trial, I feel like we're 17 days into that. That would be one heck of a catch up. Might try to catch up on it. I've got some more things to report on for the Tyrone Tucker case, so that stay tuned for that. There's some information that's going to be coming out soon that I'm going to be putting out. I'm waiting for some things to come out before I put it out there in the street in regards to things that are going on with it. So stay tuned for that. And of course, I'm always monitoring for different trials. I appreciate it, Yoga Gnome. Appreciate it. But like I said, we're going to see in this case here, it's upsetting today, but it's also why we have the appeal process. And I have full confidence that the system will work. And I do believe when the appellate lawyers get in and flesh this out and really look at the entire record of this case, it will not be over. And believe you me, this will be the type of case that will absolutely be heard by the state Supreme Court, might even go up to the United States Supreme Court with some of the issues that could be raised. So stay tuned. And, of course, looking forward to the father's trial in March to see what a jury does with it in the set of facts that they present. That's only in a couple of weeks. So definitely we'll be doing that. Sarah Boone trial, I think, got delayed again. So I don't know. We'll figure out what that next trial is. But in the meantime, I'm going to just take in what we saw here today. And I'll be back maybe later today, maybe tomorrow. We'll do some post-trial, post-verdict analysis. But, man, disappointed. I'm disappointed, but I respect the jury's verdict. And I'm looking forward to the appellate process ahead for all the issues that I think are going to be able to be discovered. And I'm sure, I hope that Shannon Smith is, not deflated, but emboldened. And I'm sure maybe, I don't know if she does appeal work, but if she does, if she's willing, if she's planning to handle the appeal in this case, hey, get that, get up, get that energy going and plow in, because there's a lot to get in and there's a lot to be argued. There's a lot to do here. The fight's not over. It's just, we got to move to the next process, but justice doesn't stop until all of it's done. And the good news is our process, when it works, and it does work, and I believe it will work in this case, it's going to get reversed. It's not going to stand. I don't believe it will, for a lot of the reasons. Rewatch this broadcast. We get into a lot of issues that are present right now. There's conflicts all over the place. There's issues all over the place. And I think an experienced appellate attorney is going to just tear this case apart. But it still doesn't feel great to watch that prosecuting team get this victory when you know the bad faith they showed throughout this case, the way they've misled the court, the way they showed up and argued, maybe I will just use the word conflicting, because I don't want to use stronger, but they made conflicting arguments in two cases. Bothers me, really bothers me. That's just me. Anyways, I appreciate everybody watching. Until we talk again, let justice prevail. It will. Have confidence. It's a process. Let it work. But most importantly, while it works, we watch and make sure that our eyes are on it. And when we need to report on something, we are. So make your voice known, guys. And until we talk again, let justice prevail. And I will talk to you soon.